Well, Henshaw here again, a constitutional coup from California. And today's video is going to be another one that you're going to love to pay attention to. Hold on just a sec here. Because we're going to be using my jury instructions, and they form an integral part of my constitutional defense document packets. And you'll learn more about that too. Send me an email, youwinnincourt@gmail.com. Because these jury instructions, and I have about close to 600 of them, and I got a bifurcated version. It only has uh, instructions dealing with citizenship, and that's enough alone to win your case. Now you get those in there and demand your trial by jury according to the common law. That may make them go away faster than anything else we can possibly do, because if you go back and take a long look at that original intent of those racist framers, they set it up to the point where we have a right to trial by jury according to the course of the common law. And that right goes back as far as Magna Carta, 1215, 800 years. And that's what we want with the common law jury. They can rule on the facts and the law. If that happens, we're going to put these bastards out of business so quick on the other end of it, you can't believe it. But that's what they don't want you to know. But when they get these jury instructions, and we're instructing them in particular on the subject of citizenship, person, and other related terms, and we wake the jury up to the fact that we're not persons, quote unquote, within the meaning of any allegedly applicable statutory scheme, because if you're a person, quote unquote, that's synonymous with the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. Oh, black is ever white here. All that bullshit sounds so great, but it means absolutely nothing, because as you'll learn, from getting my materials and studying, and with my help, that 14th Amendment did away with the sovereign independent states admitted into this union. And all we have now are federal insular territorial possessions in which Washington, D.C. thinks it has total control. But we can change all that. And not only that, we can do it quickly enough now to make things better for your children and your posterity, so they don't have to go through all this BS they're putting you through now, especially with foreclosures, evictions, homeowners, associations, you name it. There's just simply no jurisdiction because we haven't made what the Supreme Court calls a voluntary, knowing, and intelligent waiver of rights. It's nowhere in sight. And that's their bosses and our agents saying it. And that comes from a case called Johnson v. Zerps 304 U.S. 458. And I have lots of other quotes from vintage cases from the Supreme Court. And the current justices on the court know now. They also know that they've been complicit in all this bullshit up until about the last 5 years or so. A case called Texas v. California in 2020, where they refused to file the case. And you're going to learn all about that, what happened there. And they just repeated the exercise about a month ago in Alabama versus California, when you had 18 states involved, and yet the court didn't file the case. But you look at Article 3, Section 2, as the quote-unquote dissent from Justice Thomas and Alito points out, it says in all cases, A double L, in which the state shall be a party, the Supreme Court has original jurisdiction. You get there from day one. That has to be the way it is. But if you don't have any states anymore, and you're going to learn that I can prove that off the top of my head with my acapella expert witness command of 230 years of the Constitution, history, and laws of the United States, and teach you how to set an unopposed record where we do the same thing. That's going to make a lot of these cases go away. And it's also going to set them up with our unopposed record And even if it's only constructively unopposed, that will work because you didn't know, I didn't know back in the day either. I didn't learn any of this, and I went to school outside of Washington, D.C., crying out loud. And I didn't know. I was as ignorant as they come. Uh, but that's the big deal. Once you make these type of arguments and they don't go away, they're committing acts of treason to the Constitution and can be prosecuted for it and should be, especially those in black robes who pretend to be judges. But as you will learn from getting my moderately priced constitutional defense document packets, they're not judges. We're not sure what they are. They purport to be in the judicial department of government, and yet they're sitting when you walk into one of the administrative tribunals, whether it's quote unquote state or federal. That's an Article 2 administrative tribunal. Can you say separation of powers? They don't, not only do they not have any authority there, they don't have, oh, that ever present limited, if not total judicial immunity when you file a fucking civil rights claim, 42 USD 1983. And I would say 995 out of 1,000 of those get dismissed without even a hearing and without any opposition to the documents that you can file in there. And you can sometimes get fined for wasting the judicial economy of the court with sovereign citizen BS issues, also known as the original intent of those racist framers. All of that can be fixed, and we're well on the road to doing it, as you'll learn for right now. And I had hoped a lot more would happen this term than it has with the U.S. Supreme Court. I'll be talking about that in the next video. But they know exactly what I'm doing, and they know why. But it's a timing thing, and you'll learn all about that and what they have to do to keep that court in business for the next 15 years. So that said, you know, remember to send me an email, uwinningcourt@gmail.com for more information. Subscribe, tell your friends, get the word out. The quicker we start taking over our courts, the sooner we get these bastards off our back. Thank you.